Your answer deadline is one of the most critical deadlines, and that's because if you fail to file an answer in a timely manner, they can set it for a final hearing and you do not have to be notified. But that's going to be the biggest challenge, is getting the service process, because it does cost money. So if they don't sign a waiver saying I don't have to be served and you have to serve them, service process, they cost about $75 to, I've even seen some about $200. Okay. If you don't file an answer to the court saying that you've received this suit and that you want to be informed about hearings coming up, then they can have a final hearing and you don't have to receive notice. Someone was going to file on you for those that have been long-term incarcerated. It is a ground. It's not an end-all. You can still fight thing. And this is some advice that I would say for any person that's currently incarcerated and you owe child support. There's a child support order. You need to reach out to the Office of Attorney General right away. You can mail the OAG and ask them to review your child support.
Welcome back. This is Tatiana Santoyo with Texas Prisons Alliance podcast, where we bring information, education, and real conversations to individuals and families impacted by incarceration. Today's an episode titled Family Law 101, Custody, Divorce, and Legal Rights with Attorney Mary Whittington. Mary, welcome to our podcast. Thank you for joining us here. So this is going to be an important conversation for incarcerated individuals and their loved ones, and anyone who's trying to understand how family law issues can affect relationships, parenting, legal responsibilities during incarceration, which is kind of like a touch and go and inmate.com situation, because we know there's many times that the law library is supposed to assist, but they don't. So Attorney Whittington is here to help explain the key family law topics, including child custody, the divorce, the parental rights, the child support, and how someone who is incarcerated can better understand and protect their rights. So before we begin, we want to make it clear that this episode is for general education purposes only. It's not legal advice, and every case is different. Anyone facing a family law issue should speak directly with a licensed attorney or seek legal assistance when it is possible. Attorney Whittington, thank you so much again for joining us. Can you introduce yourself, share the type of law, family law you specialize in, that you do?
Sure. Thank you so much for having me. I'm very excited to share any information that I have that will help benefit inmates and their families. So you're right on point. Family law matters don't end when someone is incarcerated. As a matter of fact, sometimes it can get more complicated. And so I practice Texas family law. I've been practicing for about 9 or 10 years now. I went to law school whenever my kids graduated, so I was a bit of an older student, but anyway, I love what I do. I feel like it's an opportunity to help people when they're going through rough times. And of course, that includes our incarcerated individuals.
Definitely. Why is family law especially important for the incarcerated individual and their families?
It's super important, especially as it relates to children and the obligations for the children. Family law, for example, if you have an order for your kids before you go in order to pay child support, that child support obligation does not go away just because you're incarcerated. And so there's certain things that you can do to stop that child support obligation, because interest, those payments, and so they just keep accruing. And so by the time you get out of incarceration, you have a huge child support bill, and it's difficult enough to get on your feet without having to worry about that. So let's see what else besides the child support. The other thing that's important is that sometimes the parent on the outside will try and modify the order to get your rights terminated. And sometimes people believe that just because they're incarcerated, they don't have a right to appear at a hearing or they don't know how to defend themselves. And so you definitely do have those rights. And I hope today we can talk about some of that.
Most definitely. In regards to that, I've heard some stories. So, do you think that that would be one of the most common family law concerns that you've heard from incarcerated parents or spouses?
Yes, definitely. I've gotten phone calls from people as they've gotten out of prison, and they have this huge, tens of thousands of dollars of child support owed, and they reach out like, "What can I do about this?" And unfortunately, a court is not going to retroactively get rid of your obligation just because you were incarcerated. And so you get out with this large lump sum that's due. And again, the interest is going. And this is what I tell people too is even when you're an old person getting Social Security, they will garnish your Social Security to pay your child support obligations. And so it's just a hard situation. So I tell people one of two things you can do. Number one, you can reach out to the other parent because they can always waive that obligation for you. So if you have that good relationship, this is hindsight, of course, after it's accrued, but if you have that good relationship, they can always waive those. If you don't have that good relationship where the person is just unwilling to do that, then you should contact the Office of Attorney General, let them know what your situation is. Because oftentimes your child support was set at whatever income you were earning prior to incarceration. And so you want to get that modified as soon as possible. So the best thing, of course, is to contact the Office of Attorney General. They can work out a payment plan for you and give you an opportunity to catch up your payment and even modify your obligation to your current income level. But the main thing, and this is some advice that I would say for any person that's currently incarcerated and you owe child support, there's a child support order, you need to reach out to the Office of Attorney General right away. You can mail the OAG and ask them to review your child support. Being incarcerated could be considered a material and substantial change of circumstances that would warrant your child support obligation to at least be stopped.
Wonderful. I realized remember when that stimulus came in years ago?
Yes.
And these incarcerated individuals were applying crazy. And then they're like, wait a minute. They got this notice that they got garnished. They didn't get it. And they're like, I didn't know you owed child support. They had no idea. It was crazy. So that's when I started hearing about it.
Yes.
Yes.
And it's a real thing. So if you have to do it yourself, that's what I would tell you to do is to reach out to the OAG and ask for a review, a child support review. Let them know what your situation is and ask for a review. If you have someone on the outside that can assist you, you might consider giving them power of attorney to help you file the documents that you need to do a modification yourself. There's some forms that you can fill out for indigency. And so your filing fees and court costs and things like that can be waived. And then once you set up for a final hearing, of course, you will reach out to the library there at the prison for setting you up on Zoom.
Definitely. What is one misconception incarcerated individuals often have about custody, divorce, or parental rights that you've seen or maybe heard?
I think the biggest challenge is just the mindset that I'm in jail and I can't do anything. I don't have any rights. I can't defend myself. I can't, I think that's the misconception that many individuals have is, well, I was in prison, so I couldn't do anything, or they just did all this stuff without me being involved. So first of all, for any legal proceeding against you, you have to receive notice. And so just because you're in prison, it doesn't mean that you don't have that right to have notice. And so once you receive notice that you're being sued, either for a modification of support or divorce or whatever the case may be, you have a limited time to respond. And so that information is usually on the very first page of the citation. And I usually say just a clean rule of thumb is 20 days. But it's actually the Monday following the expiration of 20 days from the date you were served. So the prison is going to get served, and so there's going to be a date of when that was received at the prison, not when the prison puts it in your hands, but whenever the prison was served, right? So 20 days from that date. It's the Monday following the expiration of 20 days. By 10 o'clock in the morning, you have to have an answer to the court. Okay. If you don't file an answer to the court saying that you've received this suit and that you want to be informed about hearings coming up, then they can have a final hearing and you don't have to receive notice. And so filing an answer of any kind, and I've seen people take a notebook paper and just say, "Dear Judge, I'm being sued. I can't stand that person. I don't," whatever the case may be, whatever they put in there, as long as you write something on a piece of paper, it's considered an answer. What I would recommend is, of course, not to throw trash on the other party, but to say your name, where you're located, how you can be contacted, and that you want to be informed, that you do want to be informed about future proceedings. Okay. You can also enter what you call a general denial. I deny any of the allegations in the petition are true. And that's all you have to do is sign it and mail it back into the court, and that'll be your answer. So it doesn't have to be anything super fancy. Just, again, any piece of paper that you have, write to the court, notice that you've received the notice of the lawsuit, and say that you want to be informed about future hearings. And after that, you have to be informed. So if they set it for a final hearing, then they have to let you know when that final hearing is going to be. You're allowed to have a 45-day notice by law of a final hearing. And so that gives you plenty of time. When you have that 45-day notice, should give you plenty of time to reach out to the library to get set up for some type of Zoom to allow you to participate in the hearing.
Okay, thank you for that. Correct me if I'm wrong. In Texas, people often say that custody, but is the legal term conservatorship, or is it both?
It's conservatorship.
Okay. Can you elaborate a little bit, explain what conservatorship does mean?
Sure. So conservatorship is a very long legal description of custody, right? So conservatorship is actually, there's 3 types of conservatorship in the state of Texas. So 3 types of custody, right? 3 types of conservatorship. And what that means is you can have sole managing conservatorship. And if someone has sole managing conservatorship, that means that parent has all of the decision-making abilities for the children, right? The other parent, if somebody has sole, that means the other parent has possessory conservatorship. And that parent, they still have rights and duties for their kids. They just don't have any decision-making abilities. And so, but they do have a right to be informed. They have a right to consult. So when I say informed, that person has a right to be informed about education of their kids. They have a right to be informed about medical of their kids. Anything going on with their children significant, they have a right to be informed. They have a right to consult with doctors and educators and things like that. But the most common form of conservatorship in Texas is joint managing conservatorship. And so there's a presumption under the law that if both parents have acted in the best interest of their children, that they would be named joint managing conservators. And what that means is that you both have equal rights and duties and decision-making abilities for your children. That's all it means. And so what I see happen a lot of times for incarcerated individuals is the parent on the outside says, I need to file a modification because they're incarcerated. They're going to be incarcerated for a long time. And I need to be able to make all the decisions for the kids. And so because there's certain, and there's a reason why that would be beneficial for your kids if the parent on the outside had sole. One of the reasons would be if there was a medical treatment or something that required the signature of both parents. If you're incarcerated, you're not able to sign very quickly. And so it's a timeliness thing, right? That's kind of the major thing for me when I see a need for a sole managing conservator on the outside. That would probably be the main one. But otherwise, there's no reason why you can't have joint managing conservatorship while you're incarcerated.
I've heard a lot of obstacles when mothers on the outside want to take their kids out of the country and they want to get a passport, but they have to have both signatures if there's no custody order in place. And I know that's been an obstacle with the law libraries because I guess it's an affidavit that they have to sign and notarize.
That's correct. So when you go to get a passport, you have to have the signature of both parents. And the only exception to that really is, or the main exception to that is, if a parent has sole managing conservatorship. Okay. So if you have a court order and it's certified court order, you take it to the post office when you get your passports. And if that parent has sole managing conservatorship, then the other parent does not have to sign. And so that would be another benefit to having a sole managing and possessory for the parents. So if somebody's incarcerated, they would have possessory, and then the parent on the outside would have sole.
Okay. Does incarceration automatically cause a parent to lose custody or any type of parental right? I know we kind of dipped in it a little bit a while ago, but just to reiterate.
Oh, absolutely not. It's definitely not automatic. And I will tell you, being incarcerated, your rights are limited just because of the simple fact that you're not on the outside and you're not able to just go and take care of business like you normally would.
Yeah.
But in order to terminate a parent's rights in the state of Texas, it's kind of a twofold process, right? So just because you're incarcerated, the termination of your rights is not automatic. It's something that the other parent will have to petition for, or sometimes it's the Texas Department of Family and Protective Services, CPS. Sometimes they can apply for the termination of your rights, but it's twofold. So the first one is you have to have a ground for termination, right? There has to be a reason to terminate your parental rights. And just simply because you're incarcerated is not a ground for termination, okay? The second part is it has to be in the child's best interest. So whenever a parent goes to court, even if you're not there, they still have to prove up those two grounds, that there's a ground for termination and that it's in the child's best interest. So the challenge with people that are incarcerated is there is a ground that if you are incarcerated for more than 2 years and you are failing to take care of your child while you're incarcerated, that is a ground to terminate your rights. So if someone was going to file on you for those that have been long-term incarcerated, it is a ground. It's not an end-all. You can still fight. And I was, as I was sharing with you just a little bit ago, I was appointed on a case where a father was going to lose, or there was a petition to terminate his parental rights, and he was incarcerated. And we fought hard and we worked really, really hard for him. And I don't think that the court could have terminated ultimately, just based on everything that he was doing while he was incarcerated. But in order to fight, you have to have a good relationship with your attorney, your court-appointed attorney. And also you want to have a good relationship with your CPS caseworker. And I know while you're incarcerated, it's difficult, but they have to communicate with you by law. And so you don't want to be hands off. You want to be very much engaged with them and reaching out and writing your letters and doing all that you can while you're incarcerated in order to try and maintain your rights.
So you said court-appointed attorney. So if you're incarcerated, you can get a court-appointed attorney for divorce?
Not for a divorce.
Okay.
Only for termination.
Oh, termination of parental rights. So if you're inside, how can you, when you're saying be there for the child, I know monetary wise, they can't be there. Obviously, they can't fulfill that obligation. How can they show that they want to be there, although they're incarcerated? How can they show that they've been there for the child?
So one of the things that you can do, that's a great question, because I think it's so important. When you think about terminating someone's rights, remember there's two things. They have to have a ground and best interest. So because they're incarcerated and they're not able to pay for their child, they may be longer than 2 years in there, there's the ground. That's already a strike against you. You can't do anything to fix that. Not while you're incarcerated. So you have to attack the best interest. Remember, it's twofold. Termination is twofold: ground and best interest. You can't do anything about the ground, but you can focus on the best interest, and that is having a relationship with your child. So, and I know it's difficult. It's like,
Yeah,
well,
what if she doesn't allow it? What if mom, because
the
there's a lot of ladies that are they won't have it.
So what you want to do is you want to write letters.
Okay.
And I know I've heard so many horrible stories. I think they're horrible when a parent deliberately hides letters that the other parent is writing. That gets me every time. I think that's horrible, but it happens. It's a reality. So what you want to do, try and keep a notebook, or just I wrote my children on this date, and keep a log of all the letters that you've written. But keep writing. If you can call, keep a log of all your calls. If you just whatever you're doing to try your best to maintain that relationship, you keep track of it, right?
Yeah. Definitely.
That's the main thing, because you want to focus on that best interest. Especially if the children are a little bit older, you want to keep those lines of communication open as much as you can. With little ones, it is difficult because you're kind of on the hook with what the other parent wants to do. But contact the family, and you know what? A little bit of humble, be humble and ask. It goes a long way. I'm sorry for what I've done. I love my kids. I want to be there. And if you can't get to the other parent, get to their parents. Just keep those lines and those relationships going, because it's gonna help you in the long run, especially on that best interest. Because it's like,
Okay.
I have a relationship with my child, and it's not in their best interest that relationship is severed.
Definitely. If a child is living with neither parent, maybe a grandparent or a caregiver, what rights might the incarcerated parent still have? Does it still the same?
So yes, in short, yes. And that happens a lot, where I get phone calls all the time, even on people on the outside. It's like, well, I'm still paying child support, but the kids don't even live with her. And I'm like, well, if you look at your orders, if you look at your Texas orders, most of the time they're going to name a primary parent. And that primary parent gets to decide where the kids live. It doesn't say the kids have to live with the primary parent. It says they get to decide where the child lives. And so sometimes that might be with grandma and grandpa, or aunt and uncle, or wherever. And so the best thing there, again, would be to get a modification if you can, or if the main thing I think for incarcerated individuals for modification would be the child support. You want to get that stopped. But as far as when you get out and the kids are not even living with the other parent, a modification, again, contact the Office of Attorney General.
Okay. If there is some type of custody order or non-custody order, can the incarcerated parent still request communication with their child through letters, phone? Like if they want a video visit, can they request that as long as it's supervised? Or what could they do?
You can request anything, anything that you want. I think it's important to have, if you have that relationship with the parent, the other parent, then you can ask for anything. Are you asking about court?
Yeah. What if they don't? So let's just say there's no custody order in place, and they want to see the child, or they want to communicate
while they're incarcerated?
Yes.
That is going to be very difficult.
Okay.
And the reason why is the other parent is only obligated to follow the order, right? And the order will usually say the terms for visitation. And that visitation usually says pick up and drop off at a certain location.
Yeah.
And so that's all they're obligated to do, is to follow the order. So you could possibly get it modified, and ask the court to order the other parent to bring the children to you for visits, once a month. I really don't see that happening,
I
unfortunately.
agree. I agree with you, unfortunately. How important is it for incarcerated parent to keep records, letters, certificates, classes, attempts to stay involved?
Oh my gosh, so important. That's such a beautiful question because that is critical. Whenever you get out, and even while you're in there, if you file a modification, you want to be able to show the court, I'm not just sitting in here, doing nothing. I'm working on becoming a better person. Anytime you do any type of training or certification or classes or Toastmasters or whatever it is that you're involved in, um, you want proof of that because it's going to help you for any family law matter, whether it's a divorce or a modification, because you know why? It reflects who you are as a person. It's like, yes, I've made mistakes, but I'm working on improving myself while I'm here. And here's some of the things that I've done. That's critical. That's really very, very important.
So it sounds pretty much kind of like what they do right now to rehabilitate themselves so that they can be granted parole, right? It's part of reentry. They need to do things that are on their ITP, their church classes, certificate classes, and post secondary or getting their GED, just showing something that they are doing to rehabilitate themselves. Correct?
Absolutely. All of that is not just for parole, but any family law matter that you have, the court's going to want to see that. They're going to want to see that you've done work that nobody asked you to do. You did it on your own because it matters.
Perfect. Okay, now let's get into this little I think this is a very popular one, and it's unfortunate. I don't mean to laugh, but divorce questions. Can someone file for divorce while they are incarcerated? I know they can, but
Yes,
for some it's been difficult. I know we have uploaded some resources, the Pro Se handbook. It's like a 141 pager PDF one, but and I know that they're supposed to be helping in the law library, but not all of them help.
hmm
So again, can they file for a divorce if they're incarcerated?
yes. So you can file for a divorce if you're incarcerated. Even people on the outside, I tell them there's simple ways to get this done, and you can do it too. If you're incarcerated and you don't have any property that you're fighting over, or if you don't have any children, a divorce can be pretty simple. And there is a website, and I'm not sure if this is maybe some resources that we can share or upload. It's called texaslawhelp.org, and it has the forms. And you really just fill out the forms, and you get those filed with the court. And again, there's indigency papers that you can file asking the court to waive your court costs and filing fees. The biggest challenge I would think for people that are incarcerated is going to be the service of process, is because anytime you file a lawsuit, the other party has to be served unless they sign a waiver. The texaslawhelp.org, they do have waivers on there, I believe, that the other party can fill out. But that's going to be the biggest challenge, is getting the service of process, because it does cost money. So if they don't sign a waiver saying I don't have to be served and you have to serve them, service process, they cost about 75 to, I've even seen some about $200 just to serve them of notice of the lawsuit.
But with the affidavit of indigency, that should waive all fees, correct?
It should, as long as they live within the county of, like if you say, for example, Emerald is in Potter County. So if you file in Potter County, you can have a Potter County sheriff serve it. But if you file in Potter, because that's where you last lived, or where your spouse is located, or they live somewhere else, that's going to be the biggest challenge. Is if they live in a different county, you have to pay for a process server for that county.
Definitely. Okay. What should an incarcerated person do if they are served with divorce papers?
So file an answer. You want to file.
What if they're okay with it? They don't have to file an answer, right?
They don't have to. They don't have to if you don't want to be informed. But let me tell you why I think you should file an answer. Because this really happened. I had somebody reach out to me and they said, Mary, my boyfriend says that he got a divorce 10 years ago, and now he's telling me that he's still married, and he thought that she went through with the divorce. because he just signed the papers, like he did, the agreement that he was in agreement for the divorce. And she said that he told her, I just thought she took care of it. Well, she didn't take care of it. Yes. So you don't have to file an answer, but if you want to know what's going on, you should file an answer. That way you can be notified of any disposition. I got a phone call yesterday from a lady that said, well, I filed for divorce, but it's been about a year or two ago, and I'm just ready to proceed. And so I looked it up and I said, well, the court has already dismissed that for want of prosecution. And so just because somebody filed something doesn't mean they follow through with it. So the way that you're notified that they actually did follow through, file that answer, let them know that you want to be notified.
Okay. What issues should someone look for before signing the divorce documents?
You really want to look closely at anything that you may be obligated to do. So if you are obligated to give up, your entire interest in your marital residence that you've paid for 30 years prior to incarceration, you may not want to sign that. So you really want to look at, as far as a final order, if somebody presents you a final order and say, will you agree to this, sign it, just make sure that it says what you want it to, as far as division of property, any child support obligations if there's children, all of those things. You don't have to sign it just because they put it in front of you. You are very much within your right to kick it back and say, I agree to this, this, and this, but not that one. And if you don't reach an agreement, well, then let's have a hearing. But you should not give up your interest in your property just because you're incarcerated.
Okay. And you just said a keyword, hearing, and I know this has been a huge issue. How can an incarcerated person request to participate in the divorce hearing while they're incarcerated, instead of having somebody, because I know a lot of the new girlfriends, well, he signed a POA, but I can be there, but I'm sure that they would want to take care of it, then have them,
it's going to be very, the court is going to have to approve a Zoom appearance.
Okay.
So the incarcerated individual needs to write the court a letter asking for permission to appear by Zoom. And so it's actually considered a motion. So motion to appear by Zoom, it doesn't have to be anything fancy. You don't have to use fancy legal language. Just say, motion to appear by Zoom, your name, the cause number, and ask the court for permission to appear at the final hearing, or any hearings for that matter, via Zoom. The only good thing about COVID is the courts learned that we can have hearings by Zoom. So it's something that they're used to, but you do have to get court permission.
Okay, great. Let me think here. Child support. What happens to child support when the parent's incarcerated? They're going to continue. I know they're going to continue to get charged, but there's a way to freeze the interest, correct?
No. What you need to do is you need to file a modification and have all of it stopped.
Oh.
Yes, that's what you want to do.
Okay.
And again, it's reaching out to the Office of Attorney General and asking for it to be reviewed. And then if the Office of Attorney General won't move on it fast enough, then you'll need to file a modification on your own. And I believe the Texas Law Help has that also.
Okay, wonderful.
For a modification.
Excuse my allergies here. My allergies up here in Texas are killing me. Oh my God.
I don't miss that at all.
Oh my gosh. So what are child support arrears, and why is it important to address them early?
Oh, child support arrears, what that means is it's child support that you owe, right? That hasn't been paid. So it continues to gain interest, and that will eat your lunch. And so the arrears is it's back child support. So child support that was ordered that wasn't paid. And the disbursement unit for the state keeps track of that.
Okay. Question, and maybe I've heard of a lot of the guys have a little, I'm not going to ask any questions, but they got a cushion in their trust account. You know what I mean? Mm-hmm. They got a cushion there, and it's been froze. They can't get it because supposedly they owe child support, but they don't pay child support. It just sits there in the trust account frozen.
Oh, no.
I don't know if you've heard of anything like
I
that.
have not, but I can do some research on that.
Okay, that'd be great. Yeah, I've heard that.
I can definitely do some research on that.
Yeah. Because it just sits there. It just sits there. And I had somebody that would keep going to commissary and they would see the amount that they had, but they couldn't spend it. It was frozen. It was, yeah. And nobody on the outside can inquire about it. Not even if you're a spouse or anything, because that's a trust account with the incarcerated individual and TDCJ. So it's only communication for them. And we know how communication is with TDCJ. Not saying anything bad, right?
I'm surprised that they froze it and that they're not withdrawing from it.
Yeah, no, it's like straight frozen. It's frozen. It was frozen. Yeah.
I'm gonna have to look into that.
Okay.
That's good. That's one thing about being an attorney is you learn something new all the time.
I need to pick your brain in regards to people keep telling me I need to go to law school because I've been a paralegal for like 20 some odd years, right? And they're like, you should go to law school. You should go to law school. And I'm like, I'm going to pick your brain.
You can. You can do it. Think about, if you're an attorney, you can work as long as your brain is. As long as your brain's working, you can work.
You're right. You're right. And there's a need in this field here.
Yeah.
There's a little bit of everything. Now my wheels are turning.
Yeah. I was the second oldest person in my law class.
Really?
Mm-hmm. Okay. And it was fine. I enjoyed it because I didn't have the pressure that a lot of the younger kids felt. Yeah. I knew when I got out what I was, what I wanted to do. And it was I didn't have to go and make, $200,000 coming out of law school to pay for my student loans. I paid for my law school before I went and, or as it was due, I didn't have to take out any loans, praise God. But, I wasn't competing for, those big, jobs that only 10 people out of your class might get. The rest of them are scrambling around, for what's left. But, I just didn't have that pressure to outperform everybody else. Law school can be very cutthroat. And I just wasn't involved with that because it didn't matter to me. Like,
I don't think I would feel the pressure, but I'm very competitive.
Oh,
very competitive. I'm older doesn't mean that I can't do it. So knowing me, I'm like, you know what? They can be my kids, but this is on. I got this.
It was really neat. I enjoyed it. I remember thinking, looking around at these young, I want to say kids, but they're not kids. They're like 24-ish. Yeah. 23.
Which law school did you go to?
To Tech. I went to Tech.
Okay.
But it was just, I remember sitting back in class and just looking at these kids thinking, I wish I had my act together when I was that young.
I know. Here I am popping kids out at 19. I did it all backwards.
I know. I feel the same way, but it's fine. It's okay.
Yeah, definitely.
As
exactly.
Long as, you know what? Better late than never. I don't think there's any time frame. Everybody's on their own journey, right?
You're totally right.
And you can pick yourself up and get back on the right track or whatever track you want to get on. You want to be an attorney in your 40s and 50s.
Or your 30s?
Yeah, right. You can do that. But it was funny. Just when I got married, that's what happened. Is my husband is like, your job is super demanding. Is that what you wanted to do always? And I'm like, I used to want to be a lawyer. It's like, well, you should go to law school. So I did, and but sometimes that's hard work. That's what I say. Family law is hard work.
Yes, I agree. Okay.
All right. Any other questions? Do you have
yes, ma'am. What is the first thing that No, I won't ask that question. What deadlines should they pay close attention to when they're served papers or in during some type of legal process?
Yes, so for certain, again, it's the answer. Your answer deadline is one of the most critical deadlines, and that's because if you fail to file an answer in a timely manner, they can set it for a final hearing, and you do not have to be notified. So again, when you get served, pay attention to the date that it was received at the prison, because that's the date of service, and you have 20 days, the Monday following the expiration of 20 days
Yeah.
from the date you were served. So the date you were served, count out 20 days, and then that following Monday, you have to have your answer filed.
Okay.
No later than that date. If you miss it and you're like, oh my gosh, I missed it, whatever happened, guess what? File an answer anyway. File it after the 20 days.
Okay.
File it, because at least if they haven't already set it for a final hearing, then at least you can be notified.
Okay. What documents should they keep copies of?
So if any legal papers, for sure, any legal papers that you're served, try and keep those. You want to, if you get a final order, you want to make sure that you keep a copy of that, because it has your rights in it. That's the main thing. Anything, if you were filed, anything that you get served legally, you should be keeping a copy of, for sure. Was there something you were thinking of?
No. I'm all for leaving. I'm all for keeping copies of everything, but I guess,
Yeah.
I don't know. I guess, it's just so that they can know. I mean, I'm all about keeping my paper trails and everything dates and everything. To me, that's important. It's like a timeline right there that you have.
Yes, absolutely.
So,
anything that you get served, you for sure want to keep.
okay. What are some mistakes people make when trying to handle family law issues on their own?
Sometimes people, they make mistakes when they're filling out the forms. Like if they try to do it themselves and they're filling out the forms and they say it's a divorce, and they're identifying the community property that's subject to division, and they leave something off. Well, if it's not included in the divorce decree, that means it's subject to division later. So that creates future problems. You have a question about that? I see your wheels turning.
No, well, I don't know. No. Well, it may lead out, because my next question was, how can an unresolved issue affect someone's reentry after release?
Right. So
that's where I was at. That's why my wheels are turning.
One of those unresolved issues. So say that you had a house or a car, let's just say a car, and you were supposed to get the car in the divorce and it was left off, and now you have a car out there, it's in her name, it wasn't included in the divorce decree. It's like, how do you go about getting that if you wanted it, right? It's a post-divorce action. You'd want to consult with an attorney about a post-divorce action. As far as problems that people have when they get out, to me, I think the biggest issue is going to be if you are still married, you didn't get a divorce, anything it mainly affects the person on the outside. So if you are married in the state of Texas, it doesn't matter if you don't live together. It doesn't matter if you're incarcerated. It just anything that you purchase during the marriage or that you acquire is considered community property. And so if you're married and you're incarcerated and you get out and your spouse is, bought a new house and bought a new car and, all of this stuff, well, guess what? That's community property, and it's subject to division and a divorce.
Oh, wow.
So it kind of affects the person on the outside a little bit more than the person on the inside.
Yeah. I mean, imagine, and she's probably already gone on with her life, or he has, and here he comes, or here she comes.
Yes. I've read some terrible, terrible case law where people, they've bought a house, they've been paying, that person never even lived in the house. They're nowhere near. They're not on the loan. They're not on anything, and and it's subject to division in a divorce.
Interesting. What if they are not together? They haven't filed for divorce, but the wife is using his identity or her identity.
Um,
I've heard this.
that gets really sticky, um, because you have to prove. So, say for example, if you're married and your spouse is on the outside and they are getting credit cards using your social security number, they're just going online, they have all your information, they're like applying for this card and that card and running them up and all this, and the next thing you know, you get out and you've got $100,000 of credit card debt.
Or even a house.
Yeah, all of the things.
Yes.
So if you're still married, that whenever you get a divorce, you'll have to tell the court, I was incarcerated. You have to show proof. I was incarcerated when these credit cards were opened up. So you have to contact the credit card company, get when was the account open and all of that documentation and all the charges, and then present it to the court and like, this is not my debt. And I would think that's probably criminal as well.
Yeah, but when you got kids.
Yeah.
Yeah.
I get it, but I would love to know this is not my debt. Not my debt.
What is one thing that every incarcerated parent should know about their legal rights?
I think you should know that you can fight. You can fight for your rights. You don't have to give up just because you're incarcerated. If you get served, don't feel like you're defeated. The fact that you make efforts to contact the court and to be participating in any proceedings. Judges are used to seeing people not engage. They're used to seeing someone not file an answer. And so when you're incarcerated and you are showing them that you want to be part of this process, that's impressive. That alone is impressive, because most of the time people just say, what am I going to do? Yeah. So I think it's important that you follow through.
Okay. What message would you give the families on the outside who are trying to help?
So in the case of divorce or modifications or
any type of family law legal situation, like say a mom's trying to help her son.
Okay. The main thing, so in that case where a mom wants to help her son, say on visitation, right?
Yeah.
So Texas has very, very limited grandparent rights, very limited grandparent rights. And they can try and get grandparent visitation if they have a son or daughter that's incarcerated. It's a little bit complicated and nuanced, but that's something that they can do, the grandparents. If they're trying to help with a modification while their child's incarcerated, I think on just keeping tabs of what's going on the outside is a lot. Because sometimes, one parent is, following things on the outside and throwing shade, oh, they're incarcerated, they're doing this, they're doing that. And that person's out there not really doing great stuff either. And so not that you want spies per se, but it is good to be informed, because you need to know if they're not doing the right thing by your children. You need to know what that is so that you can present it to the court as well. Fair is fair.
Yeah, I agree. Is there anything else you want listeners to understand about custody, divorce, parental rights, or protecting family relationships while incarcerated?
The main thing is to utilize what you have available. And that is, writing letters, making phone calls, keeping those relationships going. A very sad reality, I'm sure that many of the incarcerated individuals feel, is alone and without support. So one thing that impresses me with some of the groups or some of the programs in the system is to help people. This is what I'm trying to accomplish, and there are people that can help you with that. Um, like you said, the law library, even though they may not help everyone the way that they want to be helped, that's a great place to start, though. Um, and then write those letters to the two programs that you hear about. Do they have those programs on their tablet on people that they can?
No, but I'm trying to upload as many resources as we can. I'm going to be uploading the Texas Law Help forms. I know they have writ writers in there, but there's nothing like seeing the most updated information, right?
Mm-hmm.
I know
Yes.
Texas Law Help has the most updated forms, and I guess they can copy it. They can look at it and copy it, and
The instructions are pretty clear.
yeah.
But
Now they can see it. They can't print it out or anything, but they'll be able to see visualize it, what it looks like, and they can typewrite. I know they have typewriters in there. They can type it out for them.
mm-hmm.
Yeah, so they can do that.
Yeah.
If somebody could, if you could leave incarcerated parents and spouses with one piece of legal wisdom, what would it be?
I think you should have a power of attorney to handle your affairs for your incarcerated individual. You can find some online. It's a pretty simple document, but I think that's the most critical thing is you want a statutory durable power of attorney, not the medical, but the one that gives your agent the authority to do work on your behalf. So for families, I think that's critical. I think you need that. And same thing if you're incarcerated, you want to name someone that you trust to be your agent, and that's through a power of attorney.
I agree with that one. Now, is it okay if I give your information at the end of this video? Mind you, audience, she is not for free. It's not pro bono, so please don't be writing her a sob story. She has to make a living. Would that be okay?
Absolutely, yes.
Okay. I'll just give your address, because if I give your email, in my newsletter, I gave my email out and I start getting all these hits. People wanted me to connect because it goes nationwide. Are you only licensed in Texas?
I'm only licensed in Texas.
Okay, so everybody who's out of state, she's only licensed in the state of Texas. But I'll give your address so you won't be getting emails on gettingoutnow.com and curious for them. So I don't know how they figured it out, but they figured it out anyways.
That's
but in regards to my real estate, but thank you for that. So yeah, she's not free. If you want to hire her or if you have any questions for her, I will put her information at the end of this. Attorney Whittington, thank you so much for joining us today. It's been a pleasure to have you here at our podcast, and hopefully I'll see you soon.
Yes, thank you so much for having me.
Have a wonderful day.
You as well.
Thank you.